Hello and welcome to the Herrington Carmichael Employment Law Update for July 2016. My name is Alistair MacArthur, I'm the head of the employment team here at Herrington Carmichael, and as always I've got 4 key developments in the last month to bring you. So let's start with the great issue of Brexit. Unless you've been living in a hole for the last few weeks, you will know that the UK has voted to leave the European Union. It's the number one question we get asked by clients at the moment of, what does this mean for us? What's going to happen when it all goes through? And the simple answer is, we don't know. So we're going to have to wait and see. We're going to have to wait and see actually what comes out through the European exit. You should expect potential changes around working time or TUPE. But as I said, we don't know. But what we will do is as soon as we hear anything, we will bring you an update on it. Next, we've seen cases in the last month in relation to the application of the ACAS code on disciplinary and grievance procedures. The cases are Holmes versus Kinetic and Phoenix Homes and Stockman. These cases relate to both capability and some other substantial reasoned dismissals. What they say is that the ACAS code on disciplinary and grievances doesn't apply to this form of dismissal. That doesn't mean you can get away without following a fair procedure. What it means is that ultimately if you don't succeed in defending an employment tribunal claim, the uplifting compensation for failure to comply with the ACAS code on disciplinary and grievance procedures won't apply. Moving onwards, what we have is the cases relating to the abuse of domestic migrant workers in the UK. The cases of Taiwo and Onu related to quite unsettling situations where a pair of migrant workers were treated quite badly within a domestic environment. They sought to gain the protection of the race discrimination legislation under the Equality Act. In a quite unsettling decision, the Supreme Court said that unfortunately these individuals did not gain the benefit of the Equality Act protections because the reason for their mistreatment was their migrant worker status rather than their race. As a result, it appears there's a hole which needs to be developed by Parliament, and the judgment of the Supreme Court certainly encourages that. So we'd expect some developments on that in the coming time and over the next few months. Finally, what we have is confirmation that come the autumn the Employment Tribunal Service is intending to publish all of its judgments online. What that means is you should be able to go and search it and see whether there are any cases relevant to issues which are concerning you. We certainly will be looking at it with some interest when it becomes published. That's it for me this month. I'll be back to you in August. I wish you all a very good day and thank you and goodbye.